leave Parliament, as well as the matters arising from the matters. So today, we are going to follow the usual format. The lead discussant will speak for about 20 to 25 minutes. Then we invite the studio audience to make comments and then questions as well as contribution. As well as our viewers at home, you can also send in your comments as well as your contribution via our WhatsApp line as well as on our social media channels. And so without wasting much time, we invite our lead discussant, Mr. Osman Al-Hassan, Esquire, to the podium. Let's welcome him.
I also have presidential height, so okay. Good evening, everyone. Before I start this, I want us to look at lay a background for this discussion, which is our governance structure, as I always say. Our governance is based on some interesting philosophical theories, which are not difficult to grasp, which is that there was sometime a society without order, and then we chose to agree to have order and to choose leaders and build institutions to administer the order. And so that if we destroy the order, we will understand where we revert to. And these philosophical theories are propounded by three people: John Locke, Thomas Hobbes, and Jean-Jacques Rousseau. All of them think that we were cast into nature with equal rights to have everything and to do everything and to survive on your own. And so the determinant of who gets what is your desire and your brute force. But how did that end us? And if you imagine what we are talking about what pertains in the animal world today. So we as rational beings have agreed to have a contract, which we call a social contract, that we have to choose a leader, which Jean Rousseau called the Leviathan, and he will distribute the order. So if you had a gun, a sword, or a stick to defend yourself or survive in the state of nature, the contract asks you to put it down. Put your gun down. Put your stick down. Put your sword down into a crucible, which is now minted as a unified power in the hands of one person or few people. And that is how come we have a social order today. And if we destroy that social order, that's where we land, which Thomas Hobbes described as a society where there is very dangerous, short, and brutish life. And I'm not sure the people who are inviting this state of nature can survive it. Sorry. Now, having come to civil society, we have laws, we have institutions who administer the laws, and we have institutions which enforce the laws. We have institutions which interpret the laws. So we have the executive arms, we have the judiciary arm, we have the legislature. The legislature make laws. The laws are interpreted and enforced by the judiciary, and the executive also take part in the enforcement and take policy decisions. So here we are with a beautiful structure But that contract is this Constitution. And so if you look at even the American Constitution, not only our Constitution, and I can say British Constitution as well, if you look at the preamble, it starts with we, the people, have, then it mentions why we have chosen to adopt this for ourselves. So we determine how we are governed. All right. So now the role of the judiciary is what is in play now. The role of the judiciary and the role of the legislature. Now the legislature has its own proceedings. The judiciary has its own proceedings, its own laws. All of them drawing their power from this Constitution and their limitations from the same Constitution. But what I want us to understand is that the judiciary is not higher than the executive and the legislature. And the legislature is not higher than the executive and the judiciary. We are to understand that they should have some check and balances and separation of powers. Now, what we have adopted for ourselves is what we call constitutionalism. We have a constitution, and constitutionalism, in short, simply, is how we prevent an abuse of governmental power against the people. When we say constitutionalism in law, that's the simplest explanation I can give. So how do we check the abuse of power against the citizen if there are no check and balances and separation of powers? That's where we are. Okay. So now, our legislature has done something, thinking it is within its powers, and the judiciary is intervening, thinking it is within its powers. So I will let us all understand what has happened, which is the conundrum we have. Now, if you look at our Constitution, the powers of the legislature and its privilege. If you look at Article 115, the legislature has a certain privilege, which is freedom of speech and debate and freedom of its own proceedings. And the Constitution says those proceedings should not be a subject of question in any court. Now, this is not to be understood as that Parliament is above all laws and that Parliament cannot be kept in check. No. This particular provision is in particular reference to the proceedings in Parliament. Now, any other thing that Parliament does which contravenes the Constitution can be reviewed by the judiciary. But the Constitution is trying to tell us that in Article 115, when it comes to its proceedings, internal proceedings, Parliament is the master of its rules. And this is a confirmation. The 1992 Constitution is a confirmation, actually, of what had pertained in the 1960s. And in fact, in a case called to for Attorney General, the judges made this clear. And that is what Article 115 has confirmed. Now, I'm talking about internal procedure. And so you find, but what is that justice and where is it coming from? It said that justice is emanating from us, but it's only to be administered by the internal proceedings of Parliament. And if they can, how? Now, let me not forget that even in the Constitution, we are told that if Parliament makes a law and that law is inconsistent or contravenes with any provision of the Constitution, the judiciary has the power to strike it down, to declare it null. So, what is the difference? Is there a conflict? That Parliament is the master of its own procedure It has freedom of proceedings or procedure than in any court of law. But here we are again, the Constitution is saying if it makes a law that is inconsistent with any provision of the Constitution, then it has someone else will declare it null, and that's judiciary. Is there a conflict? No, there's no conflict. Now, what the Constitution contemplates is that Parliament's conduct can be questioned only when it is complete. It is complete when the law is made. The law has become law. If the law is in the process of being made, where Parliament is still within its proceedings to make the law, the Constitution says that proceedings is free from any question in any court of law. I don't know if you get what I'm saying. Okay. So now let's get back to the issues. What did Article 97(1) say? Now, Article 97(1) is talking about conditions that must be satisfied for us to have a certain consequence. So that if a member of Parliament does ABC, then he said, you shall vacate your seat. Until it says that if a member of Parliament decides to leave the party on whose ticket he was elected and joins another party, one, or seeks to remain in Parliament as an independent member, then you are to vacate the seat. And then in H, it says if you go there, if the people vote for you as an independent member, and you get to Parliament, and you decide to join another party, vacate the seat. Now, this is an injunction on the MP, him or herself, not for anyone to declare the seat vacant. The Constitution says you shall vacate the seat if you do anything that satisfies these conditions. All right. So if we go to Article 97, and I don't know, it's becoming hackneyed. We've read it over and over again. If you read it, there is no ambiguity about it. It is clear. It has its requirement. Now, Order 18 of the Standing Orders of Parliament requires the Speaker to inform the House if any of the conditions in Article 97(1) happens. So the question is the announcement that brings about the fact, or the fact exists to be announced? And if someone announces a state of event and you take away the announcement, have you taken away the fact? I just want you to think a little bit, because that is the situation in which we are now. Okay, so when the 4 members of Parliament decide to do what they allegedly did, the first question we need to ask ourselves is, Article 97, has it been satisfied? Has the facts stated in provisions, Article 97(1) G and H, have they been satisfied? Has someone left a political party of which he was a member at the time of his election into Parliament? That's one. If he has left, what is his status in Parliament now? Is he an independent member, or he can leave the party outside Parliament but belong to the party inside Parliament? My position is that if you leave a party, it will be a contradiction for anyone to say that you belong to the party inside Parliament, but you don't belong to the party, you are not a member of the party outside Parliament. That's a contradiction. So if you lead a party, then the second ground is an effect. It is not something that need be told us. The moment you lead to Parliament, then you remain in Parliament as an independent member. And so the Constitution says you shall vacate your seat. Now, if you are voted or you are elected as an independent candidate, you go to Parliament as an independent member, and you decide to join a political party, then the Constitution says vacate the seat. So in the case of the one who is in Parliament now as an independent candidate and is now contesting on the ticket of another political party, the question we need to ask is whether the conditions stated in Article 97(1)(h) have been satisfied. Has he joined a party? Was he there as an independent member? If the two are satisfied, then he must vacate the seat, whether someone announces it or not. So now we ask ourselves, is there any ambiguity about these constitutional provisions? No. Okay. So, but when it happened, the Constitution says if you ever have any doubt, that is if, for instance, Mr. Speaker announces that these conditions that the Constitution has prescribed have occurred, and so the seats are vacant. If you don't understand, or if you don't agree, the Constitution says, go where? To the High Court. And that is Article 99(1). It is in clear terms. It said the question as to whether a member of Parliament is validly elected or the seat of a member of Parliament is vacant is to be determined by the High Court. So, Article 99 is clear. So now let's come to the jurisdiction of the Supreme Court. Definitely the Supreme Court has the jurisdiction to interpret our laws and to enforce the laws. Now, the Constitution makes the interpretation and enforcement of the Constitution exclusive to the Supreme Court. Exclusive. And when we say exclusive, it means it can't be shared, except the ones the Constitution itself has taken away from that exclusivity and given to another forum. For instance, if you look at Article 130, 1A, and enforce the laws, but subject to the right or the power of the High Court to enforce fundamental human rights. So which means that all provisions about fundamental human rights and liberties have been taken from the fold of the exclusive jurisdiction of the Supreme Court when it comes to enforcement. Now, what the confusion really is, what the Supreme Court is battling with over the years, it requires to be interpreted. Now, most often you will find the judgments of the Supreme Court confounding the two. Where someone asks for enforcement, they think they must interpret. And if there is no issue of interpretation, they say they have no jurisdiction. Now, but let me make this clear. Enforcement of a constitutional provision or any law is simple. It's not difficult to decipher enforcement and interpretation. Enforcement is when you have to identify a state of fact and then you compare it with the requirement of the law, and then you decide whether the state of fact or conduct is violating a provision of the law. And that we do every day. If you read the law and then you read what it says you shouldn't do and what you say you should do, and then you conduct your life accordingly, you know that if I do this and do this and do this, it will conflict with this. So if we talk about enforcement of the Constitution, we are talking about what conduct will violate the Constitution. Now, when we talk about interpretation of the Constitution, we are talking about a situation where the constitutional provision is unclear. The Supreme Court stated the conditions so clearly that a constitutional provision requires interpretation when, one, there is a provision that is not clear, which I have already said. Two, that there are two or more provisions within the Constitution that are conflicting with each other in terms of meaning and purpose. Three, that you have institutions of government whose powers are drawn from the Constitution and they are conflicting in authority as to which one has authority to do what. If the powers of those institutions are coming from the Constitution, then there's a need for interpretation of the constitutional provision that confers the authority. Finally, he said, when two rival meanings are placed on a provision of the Constitution, two rival meanings. Now, this is where most people get it wrong. It doesn't mean that if you get up today and then you just find some absurd meaning to any plain and ordinarily clear provision of the Constitution, then it becomes a grounds for you to approach the Supreme Court for interpretation. No. When they say you have to have rival meaning being placed on a particular provision, it means that provision indeed should be capable of more than one reasonable meaning. More than one reasonable meaning, and that calls for interpretation. According to the Constitution, at what time can the Supreme Court assume jurisdiction to interpret? And at what time can it assume jurisdiction to enforce the Constitution? Now, the Constitution gives you and I, as citizens, right to go to the Supreme Court to ask for a declaration that someone's conduct is inconsistent with a provision of the Constitution or contravenes a provision of the Constitution. Right? Now, that is in Article 2 of this Constitution. What does that mean? That if you do something right now, and I am of the opinion, I allege, in fact, that's the word used, if I allege that what you have done is inconsistent with any provision of the Constitution, then I go to the Supreme Court with an application asking for, this Constitution is clear what you are going to the Supreme Court to ask for, a declaration that this conduct is unconstitutional. And when the Supreme Court makes that declaration, then the Supreme Court will make what we call consequential orders to enforce the declaration. So the capacity the Constitution has given you and I is not a capacity to have a dispute about the meaning of a constitutional provision and all of a sudden then we are going to the Supreme Court to ask for interpretation. No. Someone must do something. So there must be an existing conduct, and there must be an allegation that that existing conduct contravenes a provision of the Constitution. And you must identify the provision against which the conduct violates. Then, when you go to the Supreme Court, in the course of the enforcing that they need to interpret before they enforce, they will interpret before they enforce. If there is no need for interpretation, if it is clear in its plain meaning, then they will just go ahead and enforce it. And what's the enforcement? They just declare that what you have done is inconsistent with the provision of the Constitution, and we order that you do ABC to remedy the breach. Now, it is that order that when you violate, they say you have committed a high crime. Now, why am I saying this? Which means that the Constitution has not given us the capacity to take matters to the Supreme Court for interpretation. No. How does matters of interpretation get to the Supreme Court? It is in Article 132. It said, when a lower court is deciding a matter within its jurisdiction, and then in that process, it encounters a constitutional interpretation issue. It says, stay the proceedings and refer the matter to the Supreme Court for that interpretation. And when they are done interpreting, you can now proceed with the meaning they have given to determine the matter. So in that case, the Supreme Court's jurisdiction to interpret the Constitution is not a jurisdiction to end the matter that was before the lower court. No. You can't interpret the Constitution to the effect that for it to have an effect of finalizing whatever was before the lower court to decide. When you do that, when the Supreme Court does that, it exceeds its jurisdiction. So, 5 minutes left. So, well, I didn't know we have that shit. Okay, so that is how we go to the Supreme Court with issues. Now, if you go to the Supreme Court at a time when there is no conduct to allege against, the Supreme Court is always quick to tell you that now, because we are left with 5 minutes, let me just zoom on the issue of the jurisdiction of the High Court and the jurisdiction of the Supreme Court has not arisen today. And now that is why consistency in the application of law is important, because that is all lawyers do in court. You hear us saying precedent, there was this case and this thing happened and this was a decision the court gave, and so we are entitled to that same decision. We call it stare decisis, or in short, precedents. And it is very important for rule of law. It ensures equal application of the law on all citizens. It ensures fairness. It ensures certainty of the law. It ensures that if you have a case and you go to and I have a similar case and I take it to the court, I get the same results. Now, but the Supreme Court, has it been consistent when it comes to this particular issue, its jurisdiction with the High Court? Let me wrap up quickly. Article 99 has given certain jurisdiction in addition to Article 30 the court has to enforce. Article 99 said when it comes to enforcement of the provisions that has to do with validity of election, and the question whether a seat is vacant, a question whether a speaker is validly elected, and whether he has vacated his office, these things must be decided or determined by the High Court. Now, if that happens, then it has gone out of the jurisdiction of the Supreme Court, and it hasn't arisen today. There are several cases that had happened where these jurisdictions have been questioned. Now, it was a requirement to be a member of the assembly at the time, they call it. We say that's parliament. And someone was elected as a member of parliament, and his contestant thinks that at the time he was elected, he was not qualified because some adverse findings was made against him by the Investigation and Forfeiture of Asset Declaration Committee. We call it the Jagger Commission. Adverse findings were made against him, and those adverse findings disqualified him to become a member of parliament. And instead of going to the High Court to enforce it as an election petition, he did both actually. He went to the Supreme Court also for a declaration that his occupation of parliament is inconsistent with Article 71 of the 1969 Constitution. Now, in this matter, the Supreme Court assumed jurisdiction. That time it was Court of Appeal, but sitting as a Supreme Court. Assumed jurisdiction. The same Supreme Court had to decide the same issue in Yeboah and J.H. Mensah in the Sunyani East constituency. The allegation was that J.H. Mensah, who was a member of the a New Patriotic Party, was not being hailed from there. He rather hailed from Sunyani West, but he contested an election against the plaintiff and won. And he said, no, because the Constitution requires that you are resident within the Constitution for this period of time or hail from there, and neither of them are satisfied, then you are not qualified to be a member of Parliament. And when it came to the Supreme Court, the Supreme Court was quick to say that this was a matter for the High Court. And they chastised, well, albeit honorably, they spoke against the decision of Bedima Williams and say, no, the stand they took by assuming jurisdiction was wrong, because the Constitution has taken that provision out of the exclusive jurisdiction of the Supreme Court, and so you don't have jurisdiction. Now Yeboah and J.H. Mensah. Now it comes to Sumaila Bilbil and Adamu Sekandi. Then it came to James J.T. Quayson. Then it came to this very case. Now, this very case, let me rush through because we don't have time. This very case, the question is someone's seat vacant because the person is contesting as an independent candidate while he was elected on a party ticket? Has his seat been vacant? So this is also a matter for the High Court, no doubt about it. And so if there is interpretation issue before the High Court, then of course the High Court can refer it to that Supreme Court for interpretation. But it has to start from the High Court as a court of first instance. But here, what do we see? Now, these are the few errors that are identifiable in this suit that was sent to the Supreme Court by Afenyo Kings. A lot of errors procedurally, but substantively, you will find that there was no conduct against which he alleged at the time he filed the suit, because by then the Speaker has not made any declaration or announcement. He had gone, and if you look at the reliefs, they are all in the negative. That we want a declaration that a person contesting as an independent candidate while he was in Parliament on this ticket does not amount to vacation of seat. We don't have this kind of relief. This kind of relief is not the kind of relief that's contemplated under Article 2 of the Constitution. You rather should be alleging that something that has happened is inconsistent with a provision of the Constitution or contravenes it. Not that the Supreme Court should declare that something that has happened does not amount to something. But that's what happened. That's number one. Number two, of course, it is not an issue of interpretation. Because if you are going for a declaration, you are going for enforcement. The question is, are the facts that exist satisfy the constitutional provision? Have they left the party? The party constitutions are clear about it. That if you contest as a member of the party, if you contest as an independent candidate, you have automatically forfeited your membership. So it is clear that they have left the party. Now, you can't contest on a party ticket if you are not a member of the party, can you? So the one who was there as an independent candidate is now contesting on a party ticket. And it's so clear that the seat should have been vacated. Now, When that happened, and the speaker gave the announcement, it is the announcement, rather, that is the subject of focus. And they are running helter-skelter to the Supreme Court to get it set aside. Okay, so if it is set aside, then what? Okay, assuming that the Supreme Court or the speaker hadn't announced anything, is the Constitution not at play? Is it not functioning? So basically, these are the trend of events. I thought we had more time, that I could have veer into a lot of things for more clarity. But what I will end with by saying is that this issue actually is not a legal question to be answered by the Supreme Court, if you ask me. It is a political question. The parties involved are fighting for trivialities: where to sit, name, majority. Why? This is a political question that could have been answered politically. If you don't have the numbers that will make you majority, you build a consensus. And let me say that the Constitution hasn't guaranteed any precedent majority of members of Parliament in Parliament. In fact, the contrary is the case. And we hang Parliament, but for the fact that another constitutional breach occurred that everybody overlooked. There's no way. I don't think it is right constitutional. No way. I don't think it is right constitutional for Asiama to have joined that, the MPP caucus that I'm doing business with. Okay, you are doing business with them. How come they have become 138? So you see, that is the issue. And I will end by saying, look, I think we are putting too much power in the hands of incompetent and irresponsible people. And we have to stand as a people and think again. So I end my speech with this.
Thank you very much, Lawyer Osman Al-Hassan. I think the conversation is getting more and more interesting, but unfortunately, time is not our friend. At this time. Now, time for questions, contributions, and comments. Show by hands those who want to make comments. Just two. I can see Zilla, and then I come with. So let's make it very short. Okay, come with. Yeah.
Okay, so good evening once again to comrades in the studio. Yeah, on this issue that has come up, a recently published report from Mo Ibrahim, as well as that of the Afrobarometer. But complicit in this whole issue for me is that of the executive, and the president's, as well as the executive in this case, is seen as interfering in the work of the judiciary. But in my concluding statement, because I want to be very brief, I would urge the Speaker of Parliament that in this critical moment of our democratic history, he rise up and defend the supremacy of the legislature and ward off any interference from another co-equal arm of government. Thank you very much.
Robert Johnson, because of time, can you read some few messages so that just few? Let's welcome Comrade Johnson.
Good evening, viewers. I'll be taking a few messages from our social media channels, Facebook and WhatsApp to be precise. So this is from Charles Dakor, and he says, this whole issue of majority and minority is a political gimmick being displayed by politicians to confuse Ghanaians. I strongly believe if MPP had that majority in parliament despite their members contesting independence, Afenyo Markins would not have gone to the judiciary for interpretation. The constitution and the MPP constitution is so clear, and that does not need any interpretation. Once again, this is from Charles. This is from Suleiman Ali, and says, I'm watching you live from Libya. Thank you, Suleiman. Keep watching us. This from Edem Kwashi from our WhatsApp page, and he says, rise up, comrades of Santrofi, Akpafu, Lolobi, and Likpe. 4 years of parliamentary disenfranchisement as is an affront to our sacred rights. The Supreme Court's silence is a betrayal, while their sudden consent over a constitutional crisis is a mark of hypocrisy. The forces of oppression seek to strangle our democracy, but we shall not be silenced. We shall not be deterred. We shall reclaim our nation from our glorious struggle for independence. We vow to continue the fight for freedom, justice, and equality. We reject the shackles of the state capture and demand self-determination for our beloved Ghana. I'll take 2 more and I'll be done. This is from Rose, and she says, I think the stalemate could force Parliament to rethink how it represents the people. This deadlock highlights the need for a dialogue and cooperation across party lines. This from Kwame. He says, the 8th Parliament's unique balance of power is a chance to show us a new way of governance. The stalemate, whilst frustrating, can encourage cooperation if the leaders prioritize the welfare of the country. I think there's a contribution from Ifia, and she says, this parliamentary stalemate highlights the need for a government that works not just for the interest of the powerful or political elites. True socialism demands that our representatives prioritize the welfare of the working class, creating policies that improve healthcare and uplift education. Parliament should be a space for collaboration and action, not a deadlock that delays progress for ordinary Ghanaians. It's time we rethink how we hold our leaders accountable and ensure their focus remains on the public service. Ladies and gentlemen, I think this is where I end, even though there are more messages coming. Thank you very much.
Thank you very much, Comrade Johnson. Now we'll bring our lead discussant back to the podium to come and close the discussion. Just 5 minutes, 3 minutes. Yeah, just react to some of the comments and wrap up the discussion.
Okay. I think your comment is good. As I said, it is a political question that must solve. Consensus building at this time is what we need, not legal tussles, because the Supreme Court can give the decision. But if the other side say they won't go to Parliament, there will still not be a quorum for decision. And so we will continue to be in this. And I think leadership is what we need now than judicial decisions. So I agree with you very much, building to get Parliament to sit at least before it ends its term very soon.
Thank you very much. Thank you very much. Unfortunately, this is all we have for today. Just a few announcements. Tomorrow there will be a public forum at the Freedom Center, Kokomlemle. Many thanks to our producers led by Makiza. Big thanks to our studio audience and our most cherished viewers. You made the show possible. This is all that we have for today. We will meet again same time next week. Keep your dial on Pan-African TV. We bring you nothing but the best. It's bye-bye for now.
The Accra Collective of the Socialist Movement of Ghana, SMG, presents a public forum on Palestine's resistance and continued struggle for freedom, Theme: From Occupation to Liberation, the Palestine Resistance and Struggle Towards Freedom. Date: Thursday, the 14th of November 2024. Venue: Freedom Center, Kotoko Avenue, Kokomemli. Speakers: Dr. Gamel Nasser Adam, member of the Socialist Movement of Ghana, and